Let me give you an update on just what's going on with him. So last time we spoke, Kyle Rittenhouse was in Illinois. Now he's still there. He has not been transferred yet back to Kenosha, Wisconsin. You remember this all took place in Kenosha, and he sort of at the end of the video sequence, he's running back towards the police. He has his hands up and he's got a gun on his chest and he's just sort of surrendering to the police. They drove right by him. Anyways, he left. He went back to Illinois. In Illinois, he had an extradition hearing, which means they were trying to talk about what it's going to take to essentially send him back to Wisconsin so that he can have his day in court there. So right now he's in Illinois, and he had an extradition hearing that was scheduled previously, but it got moved. There was a continuance in the case, and so it's now rescheduled for September 25th. He'll be back in court on that day for his extradition hearing. Now, that's in Illinois. In Wisconsin, what happened was the judge there actually set a bond. So in other words, the way that this worked, when Kyle Rittenhouse left Wisconsin and went back over to Illinois, the court said he's due in court. We have new criminal charges for him. He's not here. What are we going to do about that? So they issued what's called an arrest warrant for him, and they said, if you arrest him and bring him back into our custody, we are going to keep him in custody unless he posts a certain amount of money in order to get out of custody. Now remember, this is very important because Kyle Rittenhouse is 17 years old. These types of cases, these criminal charges, literally take years and years and years to go through the justice system. So if Kyle Rittenhouse is in bond, in custody for the next 2 years, that's going to be a problem for him. It's a problem for any criminal defendant. It's a problem for anybody who goes through the justice system. We've represented many people who've been in these situations, who are currently in these situations. And from our perspective, it's a difficult thing for a person to endure, right? Of course, you, as a common sense person who's never been to jail, you can understand how difficult it could be to go from somebody who, like Kyle's situation, is 17. He's, presumably in school. He's a lifeguard. He's trying to, grow up essentially. And for the next year or 2 years or however long it takes to get him out of custody, his life is on hold. And it's not just on hold, it is being dramatically impeded by the criminal justice system. So this is one of the most critical parts of a case. We need to get him out of custody so that he can get back to life, get back to school, get back to a job, show the rest of the world that this is not somebody who is out running around with an AR-15 just trying to kill people, right? This was a kid who's trying to do something productive, got caught up in a bad situation, did what he thought he needed to do to protect his life and his well-being, and now he's being charged with a crime and he's going through the justice system as a result. So the problem with being in custody for 2 years is that this is a process that is just sort of, I don't want to say it's designed to just deteriorate a person's willpower, but it absolutely does that. The system is sort of meant to just grind people into a pulp so that they have very little choice to do much fighting anymore, right? They're sort of incentivized to take a plea deal, close their case, because if they continue to fight, then they're going to continue to be in custody and they're going to continue to have this stuff over their head for a very long time. So a person in Kyle's position he's got a long road ahead of him. In other words, this process causes people to take plea deals that they may otherwise would never have taken, because they want some finality in their case. They want to get out of custody. They'll take anything. They'll just say, all right, look, yeah, I'll plead guilty to that. How much more time? 5 years? Fine, I'll take it. Because they're just tired of the process. And you have to think about the stress. Kyle's facing some charges that would put him in prison for the rest of his life if he's convicted of all of them. So to have that constantly weighing on your head, it's just incredibly burdensome. So getting Kyle out of custody is going to be a big focus. And there's a lot of work left to be done on that. He's in Illinois. He's going to get transferred back. And what we have seen thus far is the judge in the Wisconsin case. So once he does come back over to Wisconsin, the judge put a bond on his case of $2 million. So you can see that right here. This is a screen grab that I took today from the court's website itself. And you can see a couple items here. So this happened about 2 weeks ago, but Kyle, there was a warrant issued for his arrest. We've already seen that. It was issued by the judge, Mary K. Wagner, who also set a bond of $2 million. Okay, $2 million is a significant bond, But is it really that different, or is it really that inappropriate for Kyle's case? Well, that's what we're going to dive into today. We're going to look at the rules for the Wisconsin statutes that will detail what is an appropriate bond and what is an inappropriate bond. So the judge in Kyle's case did say that it's a $2 million bond. That's a very high bond. I covered this last week, that there's another defendant, Crystal, who is also out of Kenosha, who is also being prosecuted by the same DA, who had I think it was a $1 million bond that was reduced down to $400,000. And we did sort of a case-by-case comparison on Crystal's case and Kyle's case, and we saw that they sort of didn't really match up. Why was she getting a $400,000 bond, but he was getting a $2 million bond? Hers originally started at 1, was dropped to $400,000, and Kyle's is still at 2. So we want to just go through the rules, right? What are the judges looking at? What are the prosecutors looking at? What are the defense attorneys looking at? And we can see if there are any arguments that may justify getting Kyle out of custody without posting that $2 million bond, right? Now, one other important thing to note, and this is a long sort of segue here, but it's important to note that this judge, Mary K. Wagner, so this judge who posted this bond here, it really hasn't seen anything yet, right? Doesn't know much about this case at all, other than what she saw from the charges that are going to be posted, or that were posted in the probable cause statement from the prosecutor's office. That's all the judge knows. And from what we've seen here, I looked through the more recent activity on the case, but I don't see a lot of activity. There was a proposed order that happened the day after the warrant was issued, and that's about it. So I really don't know if there has been any sort of movement from Kyle's defense team to file motions to modify their release conditions, or whether they've had any presentations to the Wisconsin court. We just don't know that yet, but we will soon enough. So my point is, Mary K. Wagner, the judge who issued this bond, is sort of probably flying in the dark, or supposed to be flying in the dark. Now, this judge is going to know everything that you see on the news and in the media, but in terms of the concrete evidence that is in front of this judge, they just haven't seen it yet, or probably have not seen it yet, which is why there may be some wiggle room on this bond once Kyle does get transferred from Illinois back to Wisconsin.